O'Neill from Rockingham 30, here to introduce HB 1740 relative to protection of persons from domestic violence. Let me tell you about domestic violence victim Lindsay Smith. In 2021, Lindsay went to the Hampton Police Department with bruises covering her body and text messages from her partner saying, "I'm going to make you pay." The police sent her to civil court to get a restraining order. An advocate helped her fill out the paperwork, filled it out wrong in third person, confusing the court. Then the advocate didn't show up for the hearing. Neither did Lindsay's abuser. He didn't have to. It was civil court. The judge denied Lindsay's petition 2 weeks later. Her abuser bought a pistol and hook set. 2 weeks after that, he shot her multiple times outside her workplace. Lindsay survived after 7 brain surgeries and a year and a half in the hospital. She testified before this legislature in 2023. Her words, "The domestic violence that I endured and survived was criminal, and it should have been treated as such." Lindsay's case made the news, but these same dynamics, police punting to civil court, victims forced to be their own lawyers, abusers who don't even have to show up, play out in courtrooms across New Hampshire every day. The current statute is broken. RSA 173B has been amended so many times, it's become a patchwork that even lawyers can't predict. The New Hampshire Supreme Court recently took the extraordinary step of publicly asking for help understanding how the statute should be applied. That doesn't happen unless something is seriously wrong. HB 1740 repeals RSA 173B entirely and replaces it with clear, coherent framework. Here is what the bill does. 5 things. First, it requires police to investigate. When police get a domestic violence report, they must investigate, collect evidence, and forward the report to prosecutors within 24 hours. No more, "This sounds like a civil matter." Civil referral as a substitute for criminal investigation becomes prohibited. Secondly, it requires arrest. When probable cause exists, officers shall arrest, not may shall, mandatory. Third, it links civil protective orders to criminal charges. Under current law, anyone can file a civil petition and get an emergency order before the accused even knows about it. Under HB 1740, civil protective orders require that criminal charges have been filed and a judge has found probable cause. This is the key structural change. It puts professional investigators and prosecutors in charge of evaluating the evidence rather than forcing victims to litigate their own protection. Fourth, it makes protection automatic. Once charges are filed, bail conditions protect the victim immediately. No separate civil petition, no navigating court alone. And fifth, it protects due process. Under current law, someone can lose their home, their firearms, contact with their children, all based on a petition filled without notice. Before they even know they've been accused, without notice before they know they've even been accused. HB 1740 requires charges and probable cause first. That protects everyone, genuine victims and the falsely accused alike. Mr. Chairman, the current system fails victims by pushing them into civil court where they have to be their own lawyers. It fails the accused by depriving them of liberty without adequate process, and it fails everyone by producing arbitrary outcomes. HB 1740 fixes this by treating domestic violence as what it is, a crime, and replacing a broken statute with one that is clear, enforceable, and fair. With me today is the subject matter expert on this chapter reform, and I'd like to turn the mic over to him for further elaboration.
Thank you, Mr. Chair. My name is Dana Albrecht. I would note this is the Criminal Justice and Public Safety Committee. It's not the Civil Law and Public Safety Committee. And I think that's a good thing. Criminal justice is a good thing. The sponsor told you about Lindsay Smith. Lindsay is one of 4 case studies that we're presenting, and you have all of those. You've got packets on each case, and in there is docket numbers, source documents, sort of everything you need to verify what we're going to tell you. Here's what struck me when Lindsay testified before the legislature in 2023. She didn't come alone. She brought her close friend, Destiny Berard, and Destiny's case is the mirror image of Lindsay's. Lindsay is a victim who couldn't get protection. Destiny is an innocent person who can't get free of the system. Destiny dated a Massachusetts police officer. What she didn't know was that he'd been formally disciplined for excessive use of force. When his lawfare failed in Massachusetts, he went jurisdiction shopping in New Hampshire. Her prior legislative testimony is in your packet. I'd love for you to read that. A New Hampshire judge granted a 6'1" armed police officer a protective order against his 4'10" ex-girlfriend. The basis? Facebook posts about heartbreak after their breakup. That order has been extended for years, and it gets worse. After she testified before the legislature, different committee, Destiny was arrested for violating the order. Her crime? Attending church 2 years earlier. They arrested her on a Friday, so she'd spend the weekend in jail. I represented her under RSA 311-1 until she could get a criminal defense attorney. Another year-long saga. The sponsor and I attended her trial, not guilty, but she was still arrested, still jailed, still dragged through criminal court for an order that never should have existed. Lindsay and Destiny are best friends. They went to the legislature together. One can't get the system to protect her, the other can't get the system to leave her alone. Same statute, opposite injustices. Moving on to the next of the 4 cases. It's gotten so bad that you've got people filing federal constitutional challenges to this statute. If you look at Kelly v. New Hampshire Attorney General, it's the second case in your packet, an assault victim's abuser got a protective order against her. It's in your packet. The case I really want you to understand is the one that's before the New Hampshire Supreme Court right now, pending now. That's Mullen v. Ekman. It's one divorcing couple. It's eight separate court dockets. Might be 9 depending on how you count. 3 courts, 2 circuits. Lots of judicial resources. I'm not going to walk you through everything, but here's what the statute permitted. A woman filed a domestic violence petition. It was dismissed. So she filed again in a different court. Same husband, same allegations, different courthouses. The statute and the court allowed it. When she filed, the court issued an emergency order the same day. No notice to the husband, no hearing. The order removed him from his own home. He owns the property. He pays the mortgage. She hadn't lived there in over a year. He was out for over 7 days while the court sorted it out. And the petitioner who got this order, she's a convicted domestic violence offender herself, who had already violated a protective order her own sister obtained against her. This is nuts. Every one of these outcomes was lawful under the existing 173B. The problem is the statute. The Supreme Court's noticed. Christmas Eve, the court asked for amicus briefs, outside help to understand how this statute is supposed to work. That case is still pending. But the legislature, that's you, can act now, and you can do a much better job fixing a broken statute than the courts can, because the statute is the problem. You've got 4 cases here, 4 victims of the statute, 4 case studies. Lindsay Smith, who couldn't get protection. Destiny Berard, her close friend who couldn't get free of the system. You've got the Kelly federal case. And you've got the current Mullen-Ekman mess that even the Supreme Court can't seem to untangle. And so 4 victims of the statute, and I think that's the tip of the iceberg. I just picked kind of 4, what I thought were the ones that would really tell the story. There's other people that will tell their stories about how they're victims of the statute. Some of them couldn't be here today. You'll probably get some online submissions. And I don't want to take anything away from their experiences, But all the evidence you've got there is public records, court dockets, and you've got even the Supreme Court's own cry for help. So this bill fixes the statute. Please pass this bill. With that said, we'd be happy to take questions.
First, I'll start with, I just want to let you know, I actually do read the emails. You send a lot of emails. I do not respond because they often involve pending legislation. So I see them though, to start. So as an attorney, maybe you can help me out. You're suggesting that we take the entire domestic violence statute, toss it and start from scratch. Is that basically what this is? That's what I got from the representative's testimony.
Yes, and that we move it into a criminal justice framework away from a civil advocacy framework.
So,
Because I'll just say, domestic violence is a crime.
Right.
And just, I'm going to add to some of the testimony I heard earlier about, if we've got rapists walking around in the workplace,
yeah,
why aren't they in jail?
yeah,
That seems like it offers far more protection than a piece of paper.
sure. What about the concern, though, that victims who have been severely traumatized by what's happened to them are under this would be forced to either endure the trial process or have no protection whatsoever?
They don't necessarily have to endure the trial process.
Okay.
What they do need to do is sort of let the cops know. And even under the current system, the cops are going to find out anyway.
Yeah.
And this gets the cops there who are available 24/7. Civil courts are 9 to 4, Monday through Friday.
Right.
So this gets investigators there immediately
Yeah.
to at least get a report going, at least get a determination of probable cause.
Mm-hmm.
And then at that point, the victim can kind of roll with it from there.
Okay.
But we capture what went down as soon as possible.
Okay. Thank you very much. Any further questions? Seeing none, thank you both for your testimony.
Thank you.